Hello, everyone. My name is Dominique Shelton Leipzig. I'm a partner in the Cybersecurity and Data Privacy Group of Mayer Brown, and I do lead the firm's Global Data Innovation team, as well as the firm's Ad Tech Privacy and Data Management team. As part of our global data innovation work, I help officers and directors and chief legal officers and general counsel steer the strategy of the enterprise as it relates to growing with their technology while protecting and amplifying their reputation through data privacy. And ESG is so integral to this. A lot of people don't realize that the governance prong of ESG is already being used to evaluate data privacy. In fact, proxy firms like ISS and Glass Lewis actually rate corporations on their governance and their program. Now, you might be sitting here thinking about the 150 countries with data protection laws all around the globe, or the 2.5 quintillion bytes of data that we are generating globally per day, and thinking, how are you going to be able to get your arms around a program and demonstrate governance to excel on the governance prong of your ESG? And I can tell you that while there might be a lot of subsets to things, the reality is that there are only 6 things that really are the crux of your privacy program and will allow you to excel on the scoring for your ESG with the proxies. First, proxy advisors and others really care that there is someone at the top of the corporation that's responsible for privacy. And by the way, regulators care about that too. Regulators like the SEC and the European regulators, they want to make sure that your organization has somebody in writing in a governance policy that is responsible for the privacy and data security function. Second, they also really want to make sure that your data is mapped. If you are collecting a lot of data or your company is involved in digital transformation or digital technology or looking at accessing or unlocking the value of data, well, you are probably collecting a lot of data, and regulators, as well as those that are making decisions about recommending or giving you high scores on your ESG, they want to make sure that you know what data you have and who you're sharing it with. So inventorying the data is important. The third thing that these proxy programs look at is whether the company has actually done a legal risk assessment. Do you know what countries you are operating in and what their data rules are? As I mentioned earlier, there's 150 countries with data protection laws. Lots of times we think about GDPR, or I sit in California, or we think about the CCPA. There are actually 150 countries with data protection laws, and they all have some similarities, but also differences. And so they just want to make sure that you've thought those things through. Also, as a fourth step, if you have high risk processing, that's automated decision-making, financial services, healthcare, data that involves race, gender, sexual orientation, or otherwise. Well, those sorts of things are considered high risk or sensitive processing, and they will be looking, those that are looking at your company's ESG scoring will be looking to see if you have taken extra steps to protect that data, that sensitive data, whether you're encrypting it while it's at rest or you're taking steps to de-identify it. Those are the kinds of things that they are interested in. And then as a fifth step, they want to make sure that you are amplifying your data by keeping a very good mitigation plan in place for the risks that you might have identified in the steps that I mentioned to you earlier, the steps in your phase 3 inventory or your high risk processing. And they just want to make sure that you've taken additional steps. So external policies, that you're being a responsible data steward in terms of how you are expressing what you are doing with data to the folks whose data you are collecting, whether that be employees, B2B, or your consumers and customers. Also, internally, they want to make sure that there's internal governance in place so that you have rules and procedures and policies and trainings around who can collect data, who can have access to data, and how data should be shared outside of the enterprise. Also, they want to make sure that you have done some checking about your vendors and that they share your values as it relates to data, and that they have good hygiene too, and you're looking out for that in your vendors. Last year, data breach and cybersecurity matters cost our global economy $6.1 trillion. Put it another way, if data breach were a country, it would have been the third largest GDP behind the US and Canada, US and China. So global data breach costs our economy a lot. That is the reason that those that are involved in ranking and rating companies based on their ESG will be looking to see how your vendor management is, and do you have a process for that? And finally, they're going to be looking to see that there is training, and that training should extend not just to the employees that are responsible for responding to consumer requests, but also training should occur at the board level and also at the officer level. So those are the 6 things that you need to make sure that your board knows about and that you are operating within in your legal environment in order to get those scores where you want them to be. Look, at the end of the day, this is not an exercise about checking boxes or getting scores. It's really about having a spectacular reputation for being a responsible data steward. We are undergoing a bear market right now, and that was tripped off and started and triggered in February of 2022 based upon data privacy. And that took our NASDAQ down $1.3 trillion. Now, I'm sure there are many other contributing events like supply chain and the war, but data privacy was the trigger, the canary in the coal mine, if you will. So that is another reason why investors really care about it. And it's something that you need to care about too. So very much looking forward to continuing the dialogue with all of you about how you can use data privacy as an ESG advantage. Thank you.
I'm really thrilled to speak to all of you about global data innovation and the new team that we are putting together here within the cybersecurity and data privacy group. So what is global data innovation? It's pretty much everything that our clients are doing to amplify their work using technology, an opportunity to look at what clients need to develop in order to be successful, and then pulling together a cross-disciplinary team for them to excel. Clients are innovating with their data. They're often calling this innovation either data innovation teams or digital transformation. Their data typically does not have silos. It is around the globe. There are 150 countries now with data protection laws. So this has become an issue that is at the board level. It started out really as a compliance, a privacy, a cybersecurity issue. It is now one that is front and center in every boardroom. I wrote a book about this topic in 2019. I called it Transform, Data as a Pre-Tangible Asset in a Post-Data World. I know that there are not pre-tangible assets. There's only intangible and tangible assets, but I coined the term pre-tangible to get around the idea that CEOs and board members need to manage their data and lead in their data, very similar to the way that they look at hard assets on a balance sheet once a quarter. It turns out that the way that the laws and the movement with the pandemic is going, this is what the SEC is calling for. This is what Europe is calling for with new legislation called DORA. This idea of the CEOs and board members taking ownership and leadership over the data process. So the pandemic, I wrote that book back in 2019 for CEOs and board members. The pandemic has completely changed the dialogue. Back then, many companies, financial institutions, health packaged products, and so forth may not have considered themselves to be data companies. But certainly now, after as we're still sort of navigating our way through the end of the pandemic, there is a revolution within companies understanding that data is one of their most valuable assets. So we need to maximize that revolution with our clients. This is just a smattering of a few of the different practice areas that are implicated by data. In other words, helping clients think about how to unlock the value of their data will include not only a privacy and cyber discussion, which Raj Day and I have daily with our clients, but also product counseling on issues like algorithmic bias, IP, advertising law, employment, AI, machine learning, tech transactions, M&A, supply chain, securities, etc. The issue is when you ask the question of a CEO and board member, we've read your 10K, but what data do you need to have to excel in your three most important endeavors? That automatically triggers a discussion. I wanted to talk about how we got here. I spent the past 2 years of the pandemic once I realized that data would be in the boardroom, I went on a board journey to try to understand how things were discussed in the boardroom, what topics came up, and what were they looking at to figure out what would come on the agenda. And this slide you're looking at came from one of the courses I took at the UCLA Anderson School of Business, where I did get my certificate in board governance. And what it turns out is that the CEOs and board members often, rather than going to their general counsel, are reading the World Economic Forum's Global Risk Report that comes out in April every year to be able to determine what they should focus on as the major risks in the boardroom for the leadership to work with. And you can't see on the slide, it looks pretty small, but when you get the slide, you'll notice 4 of the risks that were identified last year were synonymous with data. Things like digital power concentration. That just means privacy and antitrust. That's an issue that comes up all the time, but the board members are looking for experts on digital power concentration, so that not calling for the experts in the law firms, they're calling for experts in the consulting firms that like EY and PwC that don't always have the information about the 150 laws that govern this area around the globe. The other thing on the slide here is IT infrastructure breakdown. It turns out that means cross-border transfer and cloud transformation. So we talk about it in different ways in the legal world than the business world. What the officers and directors are interested to know about is what is going on with data and why is it important to their business. What we are interested in talking about as lawyers is often how to get it done. So we need to pivot our discussion to be able to engage these leaders. How do we move forward? First, engaging leaders on identifying what data they need to be successful in the plans that they've outlined in their public statements or that we know about from our work. Second, helping them align their data collection to the mission. Helping them issue spot in board meetings, and this is called being special counsel to the board, helping them issue spot about the type of product counseling that will be necessary for them to excel, and as well as supply chain issues, FCPA and others, and then helping them think about protecting the business critical data, so cyber as well as IP protection. And then phase 5, the mitigation, this is what happens with the general counsel and what we do so much with our work already. And then helping the board and the C-suite have an auditable record. So there are many ways to do this. We have some exciting plans, including CXO summits, where we're going to bring the CEOs and board members together in community with our lawyers and law firm to talk about ways that we can collaborate and work together. We want to be a leadership center, a think tank in a sense, for these ideas. And we're going to engage in a lot of thinking with clients on this. Also, one-on-one presentations in boards. And with that, I think that is my final slide. I'm looking forward to meeting all of you.